So, hello everyone. My name is Marcio Cots. I'm the Chief Operating Officer for Get Global International. We are an international data privacy consulting firm based here in the US. And this is our privacy podcast. And today we're going to talk a little bit about, software development and data privacy. So today we have the pleasure to have here Jenifer with us. How are you today, Jenifer?
Wonderful. How are you doing?
I'm doing great.
Good.
I'm doing great. And the reason why we invited Jennifer to talk a little bit about software development and data privacy, it's because she's a great professional and she's been working with the software companies for a while. So, Jennifer, could you please talk a little bit about yourself and how you got involved with data privacy?
Yeah. It happened years and years and years ago when a family, and a lot of people have heard this already, that one of my family members had their data stolen and their identity stolen. So I dug through that for them and pulled all that back. And at that point, excuse me, there weren't any data breach notification rules in the United States. So that struck me as very, very odd. And then a colleague, now a colleague, then my boss, she wanted to open up an office in Ireland. So, in doing the due diligence for that work, beyond tax, beyond employment law, there was the directive at that point. And I wanted to know why. And it struck me again as odd that Europe was providing these rights, and it was a fundamental right to their citizens to have their data, their information provided back to them. And we didn't have that right here in the United States. So I dug and fell in love with the nature of the work and the nature of the changes, and left that job to go back to private practice and begin my data privacy journey. And in the course of recruiting and trying to find clients, one of my clients recruited me internally, and that was for a clinical trials health tech company. And then I worked internally for them, and then worked for an ed tech platform for a number of years. And now I'm full circle, and I am back to private practice again. Now I moved from Colorado to Texas. There's a ton of software development, software investment here in the Dallas Fort Worth area. There are a number of large tech companies with their headquarters here, but there's also a very active cybersecurity environment. One of the best cybersecurity attorneys is down the street from me, and he's wonderful. And then, using a lot of intellectual property, my background from that in New York, in a lot of this work, and it's there's a lot happening. This is again a great space to work in, but here in Texas, working and bringing on all sorts of fun clients, including several software clients. Yeah.
Okay, very interesting. We have two different worlds here with the software development and data privacy.
Mhm.
And our challenge here today is to, make these two different worlds, understand each other. Just bringing a very interesting piece of information here. Gartner uh, has released a report on global software trends and buyer behaviors insight. And on the top of the list for the features buyers rated very important when they decided to buy a software, a B2B software.
Right.
On the top of the list, there are three features that they think are the most important to make a decision in order to buy a B2B software. In other words, to bring a software, to their business, into their system, into
Right.
their environment. One of the reasons, and all of them, got like 84% as the most important feature once you decide to buy a software nowadays. The first one is users experience. The second, training and support.
Mhm.
And the other one is data privacy. Therefore, Gartner is saying that data privacy is one of the most important feature that a software should have or take care of in order to be in the market, right? Um, as many of our listeners know, Get Global International is a data privacy consulting firm. So we are based in the US, but we do have offices in Europe and Brazil, and at least Europe and some other countries. It seems that they are a little bit more mature when it comes to data privacy, right? Just because
That's one way to
it's
put it. Yeah.
yeah, I mean they have been dealing with data privacy for a longer time.
Yeah.
Let's put this way. And having this international experience, we feel that the US is taking the same path, but of course, at the beginning of the journey.
Yeah.
And we feel that a lot of organizations, they are not so worried about being compliant with the regulation because it's just beginning. Of course, we've seen more and more companies getting in trouble with data privacy in the U.S. Like 2 weeks ago, I think, two health companies got a fine from the FTC, and but most of the companies they start investing in data privacy. And when I mean investing in data privacy, is not just data protection, because of course you got to protect the personal information, but you also need to understand how you are using the personal information, and that's more data privacy. And data privacy is not just a legal issue,
Mhm.
because the lawyer is going to point and show you what you should do and what would be a liability. But someone will have to change things, and usually are procedures or train people or implement some data privacy management software, and sometimes documentation. And on that side, definitely a lawyer would help. But it seems that these companies, once they start not selling their product because the product is not compliant with the regulation, it seems that, oh, we got to deal with this. So if one of our listeners work for a software company that sells to Europe or Australia or any other country that's data privacy regulated, or nowadays if they are selling to a company based in California, Colorado, Utah, Connecticut, and the list goes on and on, we are getting to the sixth state
Yeah.
regulating data privacy in the US. When they start like not selling their product to those markets just because the software is not compliant with the regulation, then they think that, oh, we got to do something
Yeah.
on this matter. Um, how do you see this whole thing? This the necessity to work on your product and not just the whole organization. How do you see it?
Um, as it is evolving in the United States, I think what I see anyway is it's not a very, let's say, profit effective measure to take that into account. But the fact is that a lot of your engineers, your coders, your architects, they are aware of these requirements, especially if you are in a health care or health adjacent vertical where you are very, very aware of HIPAA and the requirements along with that, or I have clients in the clinical trial space, and they have to be GDPR compliant because they are working on trials in the EU. So there's software, there's companies that are dedicating definite resources to certain things such as pseudonymization, anonymization, making sure that their software as it developed tags data, follows it, categorizes it, and stores it appropriately given the nature of the data itself. But those are very distinctly regulated areas, HIPAA and trials. Now, broadly speaking, if you are health adjacent and you're not necessarily collecting data for medical treatment and outside of the HIPAA realm in the United States, you do have to worry about the newer laws. And as you mentioned, the FTC has become much more active. State attorney generals are becoming more active, even when they don't have necessarily powers under a past Privacy Act. They are using consumer protection laws, Deceptive Trade Practices Acts to assert responsibility on those companies. And so companies, even for instance here in Texas, Oklahoma, and certainly in Illinois, are having to pay attention to what they do with the data, how they use it. And I will say that BIPA, I got a call from a colleague who has works within the credit card industry, and they are worried about certain credit card machines that take biometrics, and those instances are worrying to the merchants because the merchants are just as responsible, and so they are asking those software companies to update their software. And the problem with some of these industries is that they are so there's not a lot of options, so software developers aren't the software companies aren't changing in reaction to that, but they're getting pressure from all sides because those their clients, their clients who are B2C facing and have employees that log in with biometric information now have to be responsible for that, and that's a liability for them on a number of levels. Plus, you have to, for certain levels of cyber insurance requirements, you have to be aware, you have to have certain protections in place. And as part of that data privacy work, a lot of these software companies are investing quite heavily in how they protect the data from a cybersecurity standpoint, because that aspect of privacy laws, and specifically California's law, those, if you have actively neglected to look at the security of the data that you hold, that can be upwards of $750 per instance. And if you're talking about 100,000 California residents, I think I'm correct. I think that's $75 million. So it's not, if you're talking a medium size enterprise that's growing, $75 million is crippling, if not catastrophic. So, there's a lot of push in this area. There's a software company that, definitely had needs, but these businesses, as every business does, has to weigh the risk given the nature of their market, the nature of their consumers or their business, if they're B2B, their partners, against what it takes to actually have these things implemented, have privacy by design and security by design coded in, if you want to say, into their software.
Okay, very good. You brought here 4 different topics that I just want to highlight. First, you made the distinguish between more regulated sector compared with, the whole market. So when we say that not many companies are, aware of data privacy or even don't care about data privacy, of course, we're not talking about, those sectors like financial sector, health, and so on.
Right.
right? And you also mentioned, the consumers' personal information, and but of course, there are some state regulations like the Californian
Mhm.
uh, CPRA that, or the CCPA actually,
Yeah, it's CCPA. The CPRA was the
a
vote the
complement, let's put this way,
an amendment to the
right?
law.
An amendment, right? And the employee's personal information is
Mhm.
also regulated. So that means that if your company is selling a human resource software, if your software is not compliant with the CCPA, CPRA, that means that probably your prospect is not going to consider, buying your software. I,
Yeah. Well, it depends on what the software does and how it's implemented. Workday,
mm-hmm,
for example, provides options and toggles and configuration to their platform where they provide options and the availability of certain configuration in order to help you be compliant. But that's something else that software companies do. They are the processor of the data. They are the service provider. They are not the business or the controller. So they take a
mm-hmm,
step back and say, your compliance as the business or your compliance as the controller, that is on you. Here is, we have our security in place, but and we will process it however you set up. But your your requirements in this, it's not necessarily wrong, but their processing is based on what is determined by the business slash controller, and
yeah,
those
definitely.
that
But
yeah.
I I think that most business we would like to be, to have a software that would help them,
Oh,
and
absolutely. Yeah.
and not just tell them, I'm just a tool, so whatever
Mhm.
you do, it's on your own, because you are the business, I'm the service provider under the CCPA, CPRA, I'm the processor, you are the controller under the GDPR and other regulations. I think that that approach would be, it's not a sort of a partner. Do you know what I mean?
Mhm.
It's more, it's not my business.
Right.
So I think that most software companies should start thinking, and there are very interesting cases of softwares that they do help their users, their B2C users, to comply with the regulation. Because when we say comply with the regulation, uh, we definitely need to explain a little bit about data privacy. Otherwise, some of our listeners who are not from data privacy will not understand.
Mhm.
For example, can you explain a little bit about data minimization?
Sure. The easiest way to say that is if you don't need it, don't collect it. And um, and that speaks also very, very well to your security engineers, your security professionals, because if you don't have to take care of it, then that's less stress on your operations, that's less stress on your systems, and that's less to worry about. It's a hard sell in certain, especially B2C businesses, because they want that data for analytics. They want to understand their consumer base, and you can't blame them for that. But at the same time, there's a lot of research out there that shows that using anonymized data to do those analytics is just as effective as having it pinpointed to, Susan Smith in Iowa. You just don't need that type of detail to target consumers, because those targeted ads aren't as effective as they've been perceived to be.
Mm-hmm.
That's part of that. And then, yeah, data minimization. As far as sitting down with a team that's creating the software or creating an understanding or a flow and watching how consumers or their users are funneled in and registered and how they move through their system, and they watch, if let's if you're moving through somebody's website and you're buying things and ordering things in the cart, that those engineers are building things to watch what you do and how you do it, the timing of what you do, the time of day you shop, blah, 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 all those things. So that minimizing that, even the tracking of your cursor is sometimes very, very hard to argue for. But when you explain what the purpose is behind this to those engineers, typically they will take it upon themselves to do the right. Now, I don't want to say the right thing, but they tend to find a way to do more with less. And a lot of times when talking to architects or engineers, they that there's been several times where they're like, we've circled back to this because this is the more efficient and more effective way to get this done, and there's less for us to worry about and dig through, and the metrics and the analytics are a lot clearer because we're not muddling the water with a bunch of things that are interesting but aren't necessarily telling us what we need to know. So
Got it. Perfect. So data minimization, in other words, is pretty much just collect the necessary data, right? Um, but there is another thing that I think we should talk about, which is the business purpose. Because data minimization, I would say, if I'm collecting data, personal information for one specific reason,
mhm.
and I just want to be sure that I can, you know, get in touch with the person if I may need in the future. Should I collect the telephone number, the address, the email, a second telephone number, or and the Skype ID, whatever?
Yeah.
Maybe not. So data minimization is you should collect the data for that purpose, but it doesn't mean that you should collect, different kind of data for that purpose.
Right.
And there is a different thing which is called under the CCPA, the business purpose.
Mhm.
Could you explain a little bit about it?
Well, it's akin to the legal basis in my head. That's how I as far as comparing it to GDPR, it is basically the legal basis, which you have legitimate interests under GDPR, and a business purpose in my head is the same thing as legitimate interest. It's something that the business needs. It not even needs, it's something that the business uses for purposes of the business. Now that could include marketing and analytics. Under GDPR, marketing is not, necessarily a legitimate interest. It's you have to have consent. My understanding from GDPR from a U.S. attorney is that you have to have consent. That's not so much the case in the United States. You have to provide opt-out under California law. So when it comes to the business purpose under CCPA, at this point, the regulations are out from the California Consumer Protection Agency, but enforcement of those regulations is still very fuzzy because we just don't have any precedent on those yet.
Mm-hmm.
And what So my guess is, just like with legitimate interests in the EU and the UK, that scope is going to be pushed to its stretching limit, right? So whatever a
Mm-hmm.
business purpose is here in the United States, I don't even think, if I'm remembering correctly, that there is a legitimate qualifier of those business purposes. It just has to be something that the business uses. So it can be pretty much anything, but it has to be it has to be proportionate to what a
Mm-hmm.
consumer would think you're collecting the information for. So if you have somebody that signs up for, let's say, Roblox cannot then take that data, which is used for that person to use the gaming platform, and then sell them groceries. That's not within the business purpose.
Mhm.
That's outside the scope of that. And the regulations dive into that, the commentary on that. And Colorado is tracking the California regs pretty closely as far as the business purpose can be stretched, but you can't go outside what a reasonable consumer would perceive is the purpose for that collection.
Otherwise, it wouldn't make sense to have such provision,
Mhm.
right?
Right.
Because if it's for the business, I could do whatever I want,
Yeah.
by saying, I got to collect that, I got
Yeah.
to run a business here,
You
So
could do
I
what
think,
GoodRx
yeah,
did and sell intimate health information to Facebook. So,
yeah, of
yeah.
course. And marketing is essential for any business, right?
Right.
So I would add the word need for the business just because otherwise would be, too vague, I
Right.
guess. That's how I see it. So we have two different problems to deal with: data minimization and, follow the principle of the business purpose.
Mhm.
An example that I can bring here about not being compliant with the business purpose is, for example, collecting data that doesn't have anything to do with the product or the service
Right.
that you are going to provide me. So it's a data that it's data that doesn't have any connection with our relationship,
Right.
right? So when it comes to software development, uh, these problems will have to, and those are just two examples of many things that we would have to address, when it comes to developing a software and also keeping an eye on data privacy,
Mhm.
right? Um, could you tell us any other things that you see and you have seen in throughout your experience that softwares, most of the time, software companies, most of the time, they need to take care of, besides these two examples here?
Well, it's associated with privacy, dark patterns, the use of nudging and things like that in their user experience. That is definitely something that privacy by design engineers are becoming more and more aware of. The dark patterns are specifically identified in both California and the Colorado statutes, and I believe Connecticut. I don't know that it uses the actual terminology, but it does reference, undue pressure or something to that effect. And that's one thing. And as far as what goes on within software companies, um, and the nature of privacy by design and privacy engineering is that when a company takes the time to educate their employees, to educate their C-suite, to educate their board about what the requirements are, and the more so the purpose and the, I guess for me, it's the fundamental right of privacy to individuals, including themselves, including their children. If you can explain those basic principles of privacy and the desire to be left alone to the people that work and create the software, that typically speaking, I would say 70% of the time you're going to see you're going to see that privacy by design effort happen as a matter of course, because I believe and I have seen um, people working on configuring a database, people working on code, people working on a user experience or a conversion funnel identify things that were problematic and work to fix them without necessarily reaching out to counsel or the privacy officer for advice. They then would circle back and talk about it and reach out. But a lot of times that education and that it's that education, and I call it education because you do need to you these companies do need to shift the culture, like you said. But I think educating them about why, the purpose, the nature of our day to day, people understand and agree that, I mean, most of us do not like to be tracked across platforms, and that limitation. When you talk about assisting with that, with the very nature of the software, your developers, your engineers, your architects, they are your data teams are usually very, very good about adopting that just as an innate aspect of their work. So I find education to be paramount to changing the culture, but also to seeing those things happen. A very dear friend of mine has developed, so engineers and software, all those people that work to create what we use other tools, of course, themselves, and for waterfall and agile development, project management purposes. But she's taken the nature of the laws, all the privacy laws, and integrated that with a very engineer friendly platform. So that platform can automatically those. It, I was a chemistry biochem student before I ever went into law school. So I like to check boxes. I like to know that A plus B equals C, and those things line up, and that these things are done, and they're done in an orderly fashion. And typically your developers like that too. And so they like to know, what is it we have to do? And if you can give them a roadmap, they'll take it. And
Mm-hmm.
that's been key in my experience to working to change not just the culture, but also effectuate just privacy by design by default.
Okay, I agree with you 100%. I think everything starts with getting them educated on data privacy because it's a new thing for most of us. And once they understand the meaning of it and the reason, the purpose, why those regulations are being affected, um, they most of them they agree with it. They do understand, it's going to be a big challenge because I've been most of them, I've heard this so many times. I've been working like this. This means collecting data, data lake. I don't even know where the data
They don't
is,
even
and
use the data. That's
no,
the
I don't.
thing.
We
They
don't
don't even
use the
use it.
data, but we do collect the data. We have a huge database, and most of the times they duplicate data, which under the minimization and also the security um, uh, point of view would be like a threat, would be a problem. But once you educate them, makes things easier. And I do agree with you when we bring some uh, checkbox or something like that, but a list of things that they should take care of,
Yeah.
it makes things easier.
Yeah.
And you mentioned privacy by design. For those who don't know what privacy by design, I would say privacy by design was because it has changed. I'm going to explain what I mean by that. At the beginning, privacy by design were 7 principles,
Right.
right? But nowadays, privacy by design is a little bit more than that because at least um, in Europe and in many other countries, companies they follow ISO
Mm-hmm.
standard. Here in the US is a little bit more, on NIST, but ISO has just released a new ISO on data privacy.
Right.
So now we do have like a framework or something that we can show to the developers instead of just talking about 7 principles, right? Which
Right. It was too
for
esoteric for them to implement in practice. It was just you could talk to them about it, and like I said, innately they would understand the purpose of that and the reasons for those things, but they implementing that in their in their waterfall, with putting those things into their project management sprints, those things, what does that mean in practice for the work that they do? And those ISO is great, but it's the same thing as implementing a security framework. What does that entail? Does that mean that you
Mm-hmm.
implement a certain type of firewall, or does it mean that you
Mm-hmm.
need to monitor the logs more often? What does
It's
that mean?
not a silver bullet,
Right.
right? It's not gonna solve the whole problem, and I do agree. You definitely need a data privacy professional specialized in software development in order to make the connection between, what the software does and what are the requirements, right? Because if you just explain to a software developer, the seven principles, give them, a training on the new ISO on data privacy. As you said, I mean, it's going to be hard for them to imagine how that applies to their job. So I think it's a part of our responsibility as data privacy professionals
Mhm.
to make those connections. Of course, we gotta teach them, educate them on data privacy so they wouldn't be so dependent on us
Yeah.
in the future.
Yeah.
But at least at the beginning, you gotta be hands-on and understand, how the software works. And what I mean by how the software works is front end and back end, because you might have some data privacy issues by displaying things and collecting things, or even on the back end of the software by duplicating the data, or even sharing with a third party that
Right.
the data subject wouldn't know.
And
So,
that's, yeah, that third party ecosystem of who you contract with, who you hire, whether it's, your controllers upstream or your processors downstream, those making sure that those standards, and this circles back to your point about software companies needing to implement certain things, and that is because their clients are asking for compliance with GDPR. They are asking them to sign agreements that require them to understand what they are committing to when they sign the standard contractual clauses, because that has definite repercussions. And I am currently going through a data protection agreement from a potential client, and it's overly burdensome. They're asking for things, and that's the other part of this is when you say you want notice of every single suspected event, that, I mean, your own security, your own SOC isn't going to want to do that, because that's impossible on an operational level. There's no way to provide, if you have more than 3 seats at your company, there's no way to, I just, having gone through those logs with a team, and what happens in a week for a company of, let's say, 300 people, it's unfathomable. There's 12,000 things that happen in a given week on certain endpoints, and those are real things that happen every day. So that, what all that to say, these requirements, these software companies are having to build them up because they are obligated from both ends, to meet certain standards. And a lot of this too is also driven by the California requirement that you be able to identify and delete or change or correct or provide a copy of that data. And that certainly, as a manual process, is just a nightmare, especially if
mhm.
you've been around for 5 to 10 years and you have, you know, 10 years of data that you've never deleted, you've never enforced your retention periods. That's just, it makes people like nauseous to think about going through that.
Okay, that brings me to the second point, because we were talking about, developing a new product, and
Mhm.
privacy by design
Right.
would help.
Mhm.
But there's still the legacy to that we need to manage, that we need to take care of.
Right.
It seems for me that is the biggest problem that we need to solve. All the softwares that are already implemented in many business throughout the country,
Mm-hmm.
and they are not data privacy compliant. They are, bringing liability to the companies once they are collecting data that they shouldn't, or for different reasons, or you wouldn't be able to comply with, at least some of the data subjects rights that you have mentioned under the CCPA and so on. How to deal with the legacy? How to deal with all the softwares that are, already implemented in many business throughout the country?
Oh, that depends.
That's a
um,
typical lawyer answer,
oh,
right?
very much
Lawyer's
so.
answer.
Yes, it's a bad joke nowadays. But larger. It depends on, number one, the buy-in you have from your C-suite. There are large companies whose board members and directors are very well aware that liability can reach all the way up to them now, and that publicly facing from a B2C standpoint, even if you are just a B2B company, let's say you're selling sheetrock to whole Home Depot and Lowe's, and contractors know your brand name, but what is it? Home Depot got popped by the Canadian data authority for taking users' data and passing it along to Facebook without any notice or consent or anything whatsoever in Canada. So that, and if you have, customers that are B2C that notice that, that's going to mean that Home Depot has to go back into their systems, talk to their data teams, and this is not something where you unplug. You take, this is how old I am. You take the CD out of the drive. You not disengage. You eject and delete that software off your computer. That's not how it happens for a company as big as Home Depot. That's an entire upstream, downstream assessment that requires months, if not years, worth of rework. And it's expensive. But the fact, in my mind, my opinion is that for decades now, companies, and I was talking to a colleague about this, they've amassed this almost immeasurable technical debt because they did not do these things originally, and they did not have the ability to track the data. They did not have the ability to understand what data was being leaked through an API to another service. So this technical debt is becoming, maybe it's too soon to bring up Silicon Valley Bank, but they are cashing, they've been cashing checks that they had no intention of paying for a very, very long time. And this rework, this retrofitting is going to be necessary, and you can do it piece by piece. And for companies that have dedicated silos of business, that might be possible because each silo does their own thing. But when you talk about a huge, conglomerate of companies that share data all in between and to the middle, that is going to become, if you don't have a team that understands your data flows, or if you don't have complete data flows, number one, it's never going to get done. And number two, that retrofitting, you're going to be plugging in and unplugging all sorts of software and never have a good answer or a good solution because you haven't done the hard work of understanding where your data comes from, where it goes, and what you do with it.
Most of them don't know their inventory. They doesn't even know what data they collect.
Right.
And that's pretty much what we do. That's the first thing that we usually do is like to run an assessment. And the first thing that you gotta do
It's
is
painful.
I gotta know what what kind of data you collect.
Mhm.
But when I mean you, is not only the areas, but the softwares that you have inside your operation, in your operation. So we have to go through every single software and send them like a questionnaire of like a numbers of questions to the service providers. Otherwise, we won't know what happens in that specific software, in that specific database. And some service providers sometimes they are not so friendly when it comes to helping you with that. But when you say, okay, at certain point, I'll have to write my report.
Mhm.
And if I don't get the information I need, I'm going to tell that your software is not compliant with the regulation. And that might be a big risk for your client.
Yeah.
That usually changes the whole thing. And sometimes they understand why they should have hired you to solve their problems. I can, mention
Yeah.
like 10 different clients that we were implementing their data privacy program. And as I said, the first step is by knowing your inventory, and most of them they don't know, and the personal information life cycle and so on. So we work on that, and that represents usually 60% of the whole project. People think that you're going to spend more time on changing things,
Yeah.
uh, but usually you will spend more time in getting to know, what the company does with personal information, because most of the time, as you said, they don't know, and we gotta know so
Yeah.
we can identify what the gaps are, and then change things. When I mean change things, usually procedures, training people, culture, what I call data privacy culture,
Right.
documentation, and or sometimes data privacy management software. Just because if we are talking about a big company like a retail company, it's going to be impossible to control, to manage data privacy without the data privacy software. And and that's interesting because it brings us back to Gartner's report. That's the reason why companies are so concerned about buying new softwares that are not data privacy compliance, because that will bring to me, liability. So I feel that most software companies, they should run like uh, PIA for their software. Let's bring someone to tell us
Right.
how bad or how good our software is, data privacy wise, right?
Yeah. It's there's been instances where I will ask a client to let me demo their software. Um, and typically they and it maybe it's because they don't want to see it, but maybe it's because they don't know. For instance, let's I log in, you're tracking me on the software as a visitor, and then when I register as a user, I'm assigned a number of different, for let's say better lack of better term, trackers. You have a user ID, but then you'll have different trackers for different aspects of the software that you engage with. And do you push up against certain uses quite a bit, those trackers will identify that and notify the company that perhaps you'd be interested in purchasing that aspect of the software. So there's funnels, there's triggers that are implemented, and they don't consider that PII, but those trackers, when it's not for the direct purpose of the software, the operations that you as the consumer, as even as the business anticipated, did you anticipate that certain information would be taken about your employees and their interaction with the software? Um, that's another question, especially, and it's California is the only state in the United States so far that has extended those access rights, those rights of access and notice to the business employee relationship. But I don't think it will stand on its own and by itself for very long. I do think Colorado will amend at some point to add that to that. Um, and I do think that certain states, perhaps in New York, is a very employee friendly state. Washington, Oregon, those type of states will implement employee protections as well. Just because, and this is one area where the retrofitting and the certain aspects of software development for your clients becomes very, very important. Is, how long do you hold on to the data? I can't tell you the number of times I've asked my software clients and my regular clients, how long have you been holding on to your employee data? Forever.
Mhm.
And they never delete it. And that's a massive liability if you get breached, particularly if you don't even know that you're holding that data.
Mhm. Perfect. Well, I have some of the difficulties to implement data privacy during software development. I have a list of them here just to wrap up
Okay.
everything that we
I'm going to take
went
notes.
through during this. You can list the episode on Spotify if you want, but it's up to you. Well, it seems that there is a lack of a privacy first culture, at least nowadays. I think that's one of the first things that we have to deal with. Then there is a lack of data privacy knowledge from the software developers, which is something that we also need to address.
Right.
Then it seems that we need a multidisciplinary collaboration. So it's not only the software developer, but it's also cybersecurity. It's also
Yeah.
data privacy, how we're going to manage all these things. It's the legal aspect, so also the lawyer getting involved with it. Also, I call it a lack of data hygiene. What I mean by that is we have multiple systems that can lead to what I call orphan data sets. Like we collect the data, but we are not so sure why we are collecting, that data. So that's bring us to many different situations, like duplicate the data instead of just keeping um, let's say one copy of it, right?
Or
And the
where
last,
you're, who you're sharing it with, or where you're sending it. I mean, that's
yeah,
half the time, um, especially if you have an online presence, and
hmm
there's a lot of data that gets collected through third party vendors that you
yeah,
really never even
that's
known.
the last item of my list. Service providers. I think that's a big thing that we need to take care of, right? Because sometimes your software, especially if you are a SaaS, a software as a service, that means that the data will be probably stored under your responsibility, right?
Yeah.
So that brings to your business, uh, more liability once you are storing the data. But anyway, thank you so much for this insightful podcast. I know this topic is a little bit more technical, I would say so. Not so on the legislation,
Yeah.
because as I said, I've been working with data privacy for almost 10 years in Europe and some other places. At the beginning, everything is all about
The law.
lawyers and the law. We got to understand the law. But at certain point, everybody or most of the people already understand how it works. So we need to dig in a little bit deeper. And that's what we are trying to bring here. It's like how to apply the law in certain situations. So thank you so much
Of
for
course.
helping us
Yeah.
with this
No,
challenge.
I love this stuff. This is near and dear to my heart. Is privacy engineering. It's essential, especially as our world continues to grow, and it has to. If this can be done at the beginning of the work, not only is it going to grow with the company as the company grows, and people are always going to be mindful of it, but it's a lot less expensive, it's a lot less disruptive, and in my opinion, the the brand value and the consumer trust, the partner trust that comes along with these things, these procedures and processes that are implemented are are the ROI on that is, I don't even know that it's measured accurately, because I see it every day. My clients are having to meet these standards, and when they do, and when they're accurate and real about what they are capable of doing and providing, it goes such a long ways with their clients. It just it's important.
Okay, perfect. Thank you so much for your time.
Thank
I
you,
really
Marcio.
appreciate it. And thank you, everyone, for being with us. I would recommend you guys to check the other episodes. The last one was with Aaron Weller. He's the data privacy officer for HP. So it has a little bit, his topic has a little bit to do with what we have discussed here. So remember that our podcast uh, tries to bring to our listeners different point of views and trying to help to build this data privacy culture. So that's our goal, our mission. Hopefully, we have achieved it today. And thank you, guys. See you next time. Bye bye.